Hey everyone, and welcome to This Explainer. We've got a seriously fascinating, high-stakes constitutional clash to unpack today. It's honestly a classic David versus Goliath story. On one side, you have an everyday farmer, Chief Lesapo, and on the other, a massive state institution, the Northwest Agricultural Bank. What unfolds between these two is a legal battle that gets right to the very heart of our fundamental rights, the rule of law, and, well, what happens when powerful institutions decide they want to play by their own set of rules. Let's get into it. Picture this for a second. Imagine you hit a rough patch and fall behind on a payment. Suddenly, without a single warning from a court, without ever seeing a judge, a debt collector just shows up at your door and takes away your most valuable possessions, your entire livelihood, just gone, in an instant. You probably think, no way, absolutely not, they can't do that without a court order, right? Well, that exact unbelievable scenario is what sparked the constitutional crisis we're looking at today. So this whole thing kicks off with a totally standard transaction. A farmer, Chief Lesapo, really needed a boost for his business. He borrowed 60,000 rand from the Northwest Agricultural Bank to buy some essential farming equipment. It was a totally normal loan agreement under this specific law called the Northwest Agricultural Bank Act. But, as you'll see in a minute, the rules governing this particular loan were actually anything but standard.
Part 1. The Farmer and the Bank.
To really grasp the gravity of this case, we have to talk about the real-world stakes for Mr. Lesapo. This wasn't about him losing a luxury car or a fancy holiday home. This was literally about his daily survival. He bought 2 tractors, a planter, a 10-ton trailer, a chisel plow, and a soil master without loan, and he pledged them as security. Now, if you know anything at all about agriculture, you know a farmer simply cannot work without these tools. By putting this heavy machinery up as collateral, Lesapo was staking his absolute livelihood on his ability to pay the bank back. Well, times got tough, as they do, and Lesapo fell into arrears. He defaulted on the loan. And man, this is where things escalated at lightning speed. Under a very specific rule, Section 38(2) of the Banks Act, when Lesapo couldn't pay, the bank just directly wrote a letter to the messenger of the court. They literally ordered him to seize and sell Lesapo's tractors and equipment. Do you notice the glaring omission there? There is no judge. There's no court hearing at all. The messenger, who normally acts as this neutral officer of the court, was suddenly acting as nothing more than a private collection agent for the bank. Part 2. The rule against self-help. Okay, so this brings us to the core legal mystery of our explainer. How exactly does a bank just completely bypass the judicial system? To understand why this is such a huge problem, we need to break down a legal concept known as self-help. It basically means taking the law into your own hands to enforce a claim, completely skipping the permission or process of a recognized court. And look, in a functioning democracy, nobody, not you, not me, and for sure not a powerful bank, is allowed to just act as a vigilante. This brilliantly illustrates exactly why courts matter so much. Justice Mokgoro, in her judgment on this case, actually cited this incredibly powerful quote from legal scholar Eduardo Couture. A civil action in final analysis, then, is civilization's substitute for vengeance. The entire reason we have a court system is to stop the chaos of individuals or huge institutions settling scores on their own. It replaces primitive vengeance with, a peaceful, institutionalized way to resolve disputes. And this principle is so crucial that it's physically written right into the highest law of the land. Section 34 of the South African Constitution guarantees that everyone has the right to have any legal dispute decided in a fair, public hearing before a court. This cemented Lesapo's fundamental right. Before anyone could just roll up and take his tractors, he absolutely had the right to be heard by a judge. Part 3. Judge in its own cause. So we've got a massive collision here between 2 pieces of law. The bank's unique statutory powers essentially crashed headfirst into Lesapo's constitutional rights. On one hand, you have Section 38(2) of the Northwest Agricultural Bank Act, which explicitly allowed the bank to seize property without recourse to a court of law. But then, on the other hand, the Constitution explicitly guarantees a fair public hearing. You really don't need a law degree to see that these 2 rules simply cannot exist in the same universe. Justice Mokgoro pointed out something incredibly profound about this. By completely sidestepping the legal system, the bank was literally usurping the power of the courts. Think about it. The bank was deciding if it had a valid claim, deciding the outcome of that claim, and then enforcing its very own decision. It had morphed into the accuser, the judge, and the executioner, all rolled into one entity. Part 4. The bank's defense. Now, To be totally fair, there are two sides to every story, right? Let's take an objective look at how the bank legally tried to justify all of this. They argued that their extreme powers were actually a necessary, justifiable limitation of constitutional rights. And their defense was pretty practical. They said, look, as a statutory body, we are entrusted with scarce public funds meant to help foster agriculture. If farmers default, the public loses money. So they argued they desperately needed a fast, effective procedure to recover those debts. By skipping the courts, they avoided normal legal delays and massively reduced their legal costs, which meant more money was kept available to lend out to other farmers. On top of that, the bank's lawyers argued that this harsh rule was really only meant to be used when there was no actual dispute from the debtor about owing the money. Kind of like, hey, we only do this if they admit they owe it. But the Constitutional Court looked at the cold, hard reality of the text. Section 38(2) didn't mention or require the absence of a dispute anywhere. The law just flat out gave the bank the power to seize property, regardless of whether the farmer was disputing the debt or not. Part 5. The final verdict. So the Constitutional Court had to perform this massive balancing act between the state's very real need for efficiency and an individual's fundamental human rights. They did what's called a proportionality test to weigh the two sides. On the bank's side, how much time and money were they realistically saving? The court found it was actually minimal. The bank still had to issue demand notices and wait around for responses anyway. But on the farmer's side, the harm was just devastating. Seizing heavy farming implements without a hearing could completely and unfairly destroy a person's entire livelihood, all based on a totally one-sided decision. Plus, the court reasoned that the bank didn't actually even need this extreme constitution-breaking law in the first place. Why? Because less restrictive means already exist. If the bank is super worried about a defaulting farmer trying to hide or sell the tractors, they can simply go to a court and use ordinary, expedited legal procedures like an urgent interdict to freeze the assets. That way, they can protect the public funds while still actually respecting the judicial process. And that leads us right to the climactic verdict from Justice Mokgoro. She delivered this absolute mic drop moment stating, respect for the rule of law is crucial for defensible and sustainable democracy. There is no room for legislation which is inimical to a fundamental principle such as that against self-help. With those exact words, the Constitutional Court struck down Section 38(2) of the Northwest Agricultural Bank Act, declaring it completely invalid and unconstitutional. A massive victory, not just for Lesapo, but for the rule of law itself. So, what's the big takeaway for us here? Well, this case is a powerful reminder that efficiency can never, ever be an excuse for tyranny, no matter how small the scale might seem. It challenges all of us to look at the systems operating around us. How secure are your rights if the institutions you deal with are allowed to write, judge, and enforce their very own rules? The courts exist for a reason, to protect the little guy from the overreach of the powerful. Thanks so much for joining me for this explainer. Keep asking those big questions and always keep defending your rights.